The following is a live copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Where is Fred? Fred Penny not here. Hi, I'm Todd Cunin.
Todd.
What? Hello, Todd. Hi, my name's Todd. I'm a Radio Law Talk host. Hi, Todd.
My name's Todd. I like to party.
Yes, it's been 5 days since my last opinion. Yeah, it's been 5 days since my last decision. That was the what was it? The Husbands Anonymous. Hi, my name's Todd. I'm a husband. It was back when I was married. Hi, Todd. It's been 5 days since my last decision.
We're sorry, Todd.
I don't know. Two nights ago, I was tempted to have an opinion, but I called my sponsor, helped me through it. So, seated to my left, you hear the giggles and the laughter from Seth Madden, former call screener, now illustrious attorney. He's left us from his call screening duties because
I was relieved.
You were relieved, as in, whew, or somebody relieved you of those duties.
Both.
Okay, all right. It's always, I practice criminal law, and we go into court, and the public defender will come in and they'll represent a case for somebody, and then after a while they don't like this. And we'll talk about reasons why somebody might want to change attorneys in the middle of a criminal case. But when that happens, the new attorney substitutes in private attorney, and the court will say the public defender is relieved. And I always expect the public defender to go, "Woo, man,
yeah,
that had a
riddance."
But Todd Kuhn, behind the glass is Cal Hunter. Cal, how are you on this fine morning?
I'm great, thanks. How are things on the studio side of the glass?
Well, we're getting by. We're getting by, but we will be getting by even better if we are able to roll into a case or no case, if you're ready for that.
Or we figure out who painted that rock in the corner.
Yes.
So we do have that. Well, what's your pleasure, Cal? How would you like to go about doing this?
I'm wide open on this. You want to do case or no case? I can do case or no case. It matters not to me.
Cal is like the spread offense, wide open. Yeah. Okay. So
wherever the opening is, I'll throw the ball.
Okay, so let's go ahead and do some case or no case. Why don't you roll it?
All right, here we go.
Now it's time to play Case or No Case.
Yay! And now, Case or No Case on Radio Law Talk, heard coast to coast and border to border, and always live on RadioLawTalk.com.
Sounds like
a family from Nebraska, the Bob and Janet Williams, and their kids decided to toss everyone in the station wagon. This was in 1969. And head to Disneyland. They especially wanted to ride the Matterhorn. Everyone did. This trip was over the Christmas vacation season, so a time when the park was not as busy, the so-called off-season. They got there, paid their $22 for adults, $15 each for the three kids. Boy, those were the days, right? And they went in and went on. They did not go straight to the Matterhorn because there were so many other things to see and do, virtually no lines or anything. They were loving it. And then they got to the Matterhorn. Closed for maintenance, will not be open for 4 more days. Now, remember, they drove from Omaha. And by the time their drive back to Omaha, with school starting in just 5 days, 3 days drive time, they said, we can't stay, but we came to ride the Matterhorn. Their expenses for the trip back in those days were over $1,000, a sum which they had carefully saved. Nobody told them the Matterhorn was closed when they called and asked about tickets. No signage at the front of the park said it was closed either. So once they got back home, they picked up the phone to see about getting Walt Disney to give them back their money. And so I ask you, case or no case? Todd Cunin, you get to go first this time because Seth Madden went first in our last query here. So what say you? Is this a case or is it not a case?
Well, let me ask you a question here, Cal.
Sure.
So they drove across country from Omaha, Nebraska to Disneyland.
In the Ford Fairlane station wagon.
Now, my question is,
I don't know.
Even though the parking lot was empty, did they park at the very end because, hey, we'll be the first to leave when the park closes, kids? Was Grandma strapped to the roof after she passed away?
This was not Clark.
Was John Candy there?
Yes. Did they happen to pass Christy Brinkley Brinkley in a Ferrari.
No, but she passed them.
She passed them. Did the dog urinate all over the the lunch?
No,
your scenario sounding a lot like Vacation, but
well, it is Vacation. That's the point. Yeah.
Which was loosely based on the novel The Grapes of Wrath, by the way,
yes,
I believe.
Right. Loosely.
So
except for the Christy Brinkley part.
Yeah, well, you have to take some creative license there.
Right.
So I am going to say that this is a case. And here's what I'm going to do. I'm going to say that this is a case, and in that it actually happened. I don't know if a case was ever filed, because as you say as you have said it, Cal, there was they went across, they came back, and they decided to contact Walt Disney to see if he would reimburse them. So my answer is going to be that this is an actual occurrence. It happened. They contacted Walt Disney, and that Walt Disney refunded, out of the goodness of his heart, part of their either refunded or did something to try to make up for the fact that when they got there, the Matterhorn was closed, given the length they traveled, that this is a feel-good story about Mr. Disney and how he tried to do right by somebody that came. So that's my answer.
Fair enough. Seth Madden, what say you? Case or no case? And by the way, remember your points are all going toward Denise Dirks, and you already won for her 2 points last time we had the get-together here.
As a previous proud owner of a 1989 Chevy Caprice station wagon.
Now you're talking. Yeah, mine was a Chevy Caprice diesel, by the way.
Ooh,
yeah.
Yeah, mine had the third fold-up seat.
Yes,
You'd be
of course.
surprised how many people we could get in that thing.
Must have, yes.
I'm actually going to say that it is not a case. That it's all made up. That Cal lives in his fantasy world with the Matterhorn. Therefore, there are no prevailing parties.
So you're saying that I just BS'd my way through this whole deal, and then
you got to remember, I sat behind the glass with you for a very long time.
Apparently too long. That's all I can say to that.
That's interesting, because the points that he has goes to Denise, right? And Denise recently has been the one. I mean, the only way that to answer this like Denise would have answered it is if you had gone on, say, a 2-minute explanation of both sides and made a great point, and at the very end said, and it's no case.
Yeah.
That's a Denise answer.
So we're disappointed in you, Seth, basically, for the lack of brevity.
Don't worry, I probably won't be back. I'll wait for my Monday morning critique.
Well, I think what we'll do here, because we now, with Seth's brilliant case of ad-libbing, I think,
and brevity, the word of the day.
Yeah, soul of wit.
Do you have any questions, anything you want to throw out?
I'm just thinking out loud to Seth, how can you possibly think that a family could go from Nebraska to Southern California under the false impression that the Matterhorn was going to be open, and then have this not be a case? I mean, this is a big deal, I'm telling you.
Well, I say that because I've been to amusement parks with a thought in mind. Oh, I'm going to go visit this, or I'm going to go on this ride, and I get there, and it's closed.
And what are your thoughts on that?
My thoughts are, I look at my ticket and it says there's no refunds.
But how far have you driven, or what trouble have you put yourself to get to that? I mean, that's the real question.
Can I ask a quick? Cal, when did Walt Disney die?
Walt Disney, I don't know, 68?
68.
Like
so Walt Disney, Disneyland opened in when? The 50s?
Yeah, early 50s.
Early 50s. So
late 50s, I'm sorry.
So it was the late 50s. There weren't a whole lot of amusement parks to the extent of Disneyland. And if he was still alive for them to call, that may change your answer given what they can expect when they go to a park, given that Disney was still alive for them to make a call. But we're going to go under a break. I'll tell you what, I would not object to him being able to think about it and give his answer after the break.
Seth, we'll let you do that. Give you a moment to think about it, because we have to take a little break here. First break of this particular get-together of Radio Law Talk. You stay right there, and we remind you that you can listen to Radio Law Talk on your favorite radio station, and we're glad you do that. And you can also listen to it live Saturdays 9 to noon Pacific on RadioLawTalk.com.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to RadioLawTalk.com.
I am Cameron Levitt, Chief Operating Officer of Concussion Medical Clinic. California's first concussion medical clinic is now open. As concussions increase each year, there has never been a greater need for concussion specialists. Our physicians at Concussion Medical Clinic are board certified in pediatric neurology and sports medicine and have partnered with universities, hospitals, and rehab clinics to expedite the recovery process. Simply put, we are elevating the standard of care. When you need an expert concussion opinion or concussion care, visit concussionmedicalclinic.com to schedule your appointment.
Jason Ross back here with Fred Penny, managing attorney from Penny & Associates Injury Lawyers. Now, Fred, what type of cases are you dealing with now, and what sets you apart?
Jason, we help people with all types of personal injury cases. We're former insurance company trial lawyers. We understand the other side, which gives us a distinct advantage over our competition. Remember, we don't get paid unless we win.
That's Penny & Associates Injury Lawyers with locations throughout California. For a free consultation, go to pennylawyers.com or give them a call, 1-800-616-4LAW. That's PENNEY lawyers.com.
Hi, my name is Lily. My mom and dad used to fight about money all the time. Then one day, I heard them talking about this guy, some uncle I never knew, called Uncle Sam. Well, they say this Uncle Sam guy wanted them to pay him like $1 gazillion, and they didn't have $1 gazillion. So they called this company they heard on the radio called the Tax Doctor. And the Tax Doctor worked with Uncle Sam's people. I think they're called the IRS. And they were able to work it out so my mom and dad didn't have to pay Uncle Sam very much money at all. So now mom and dad are happy, and I'm happy too. Thanks, Tax Doctor.
If you owe $10,000 or more to the IRS or state, call now and pay less.
800-263-2610. 800-263-2610. That's 800-263-2610.
This is Denise Sturks. We can represent clients in divorce, legal separation, child and spousal support, custody, termination of parental rights, step-parent adoptions, guardianships, and even conservatorship matters. Call 1-877-886-7186 for a consultation.
The law offices of Denise L. Dirks provide family law services in Northern California. When the law affects your family, call 877-886-7186. The family of attorneys at Denise L. Dirks is here to help.
Hi, I'm Frederick Penny of Penny & Associates Injury Lawyers. I bet you're tired of hearing lawyer commercials. So just relax and listen to music for a few seconds. When you or a family member has been injured, call 800-616-4LAW or see us at pennyandassociates.com. See, that wasn't so bad.
I'm a veteran. We hit a mine in Vietnam. When I came home, I didn't know where to turn.
As America's veterans face challenges, DAV is there.
My victory's been never giving up hope. My wife is always there to remind me we have a life to live.
DAV provides a lifetime of support, helping veterans of every generation get the benefits they've earned.
I am a veteran, but after I got out, I spent 2 years alone and homeless.
Every year, DAV helps more than 1 million veterans so they can reach victories great and small.
My victory was finding the support to get back on my feet. Now I'm getting things right with my family.
I finally admitted, with my PTSD, I wasn't doing well.
But there's more to be done and more victories to be won.
Now I wish I'd found DAV sooner. I am a veteran. My victory is just enjoying each day.
Help support more victories for veterans. Go to DAV.org.
Is this real life?
Time to get back to Radio Law Talk on RadioLawTalk.com and on your favorite radio station.
Well, if it's not real life, it ought to be. So we're in the middle of Case or No Case. We have the case of the cross-country trek to Disneyland. And, Cal, why don't you reset it up for us, and then we'll get into what's actually going on.
Bob and Janet Williams take their kids in the station wagon. They want to ride the Matterhorn. They get to Disneyland. They ordered tickets on the telephone back in the day. They wanted to ride the Matterhorn. They get there and do all the other stuff. They, walk their way through the park, make their way to the Matterhorn, and bam, it's closed, and it's not going to be open for 4 more days. And they came all the way out from Nebraska primarily just to ride the Matterhorn. So they're upset. They drive back home. Their kids are all, can you imagine the drive home from L.A. to Nebraska after your kids don't get to ride the Matterhorn? Mommy and Daddy, you stink. I hate you. The whole thing like that.
I can imagine the ride home from L.A. to Sacramento.
Okay, well, there you go. There you go. It was bad enough, right? And so they thought maybe we should reach out to Walt and see if Walt will give us a refund and maybe cover the $1,000 that we spent to come to his stupid park. Seth said it's not a case. Todd says it is a case. And whom did you say?
I said well, okay. I said it was a case, and I don't think that anything was actually ever filed, but I said it was a case in that it happened, and they did call Walt or tried to get a hold of him, and the outcome was Walt did something to try to make it good by the family.
Try to be gracious to his fans.
And we went to a break to give Seth an opportunity to reflect on his
just to think.
And I thought some more, and I thought a little bit longer, and then I thought about my thoughts, and I came up with, you said this was in 1979?
1979.
Walt Disney died in 1968.
Right, but that doesn't mean that it was Walt. It's a company, and that was owned by ABC Television then, by the way. ABC TV.
Oh, see, the point I was trying to make was that you said they called Walt. And
the metaphorical Walt.
Okay, so I got to amend my answer that the Disney Corporation tried to do something nice.
Try to make it right.
Yes.
Okay. All right, so for those of you who say this...
Well, are you
I'm sticking to it, man.
Okay,
no case.
Right. Those of you who say this was a case... The answer is, of course, it's fake. It's as fake as a $3 bill and a 35-cent piece.
I should have known the similarities to Vacation.
I know, but next time we get together, I take you to the city of Portland, Oregon.
You smell that, Todd?
Where a homeless campsite causes problems.
Where a what?
Homeless campsite causes problems with the local business. So that's coming up next time on Case or No Case, and that's it for this hour.
Where are we at for points?
Well, right now you've just picked up 4 points.
Well,
Todd's
four
picked
points
up 1.
total.
Yeah.
Yes.
Todd's picked up 1 so far. So Todd has 13. Denise has 12. Oh, boy.
Oh,
there's one more case or no case left. We'll see how this all plays out. Denise is not going to want to show up. Let's have Seth play for me.
I'm going to phone a friend.
Seth says, probably not going to be back. Not if Denise has anything to say about it.
The way this is going.
And even his answer when we came back for the break was more Denise-like, where he talked about thinking about it and doing all this, and then told us he wasn't changing his answer.
And that
I was trying to eliminate the brevity.
Yes. Harvey Weinstein, on the heels of that, failed rides at Disneyland. The Harvey Weinstein experience. Harvey Weinstein back in the news. He's got his case going, and he has shaken up his legal team.
Well, that's an understatement.
Yes. Having a difficult time finding representation. Look, any attorney, if you're willing to pay the money, I'll represent you. But having the ability to find representation that he can agree with on legal strategy and going forward.
And let me say this. Anybody that's going to be in, I don't want to say in Harvey Weinstein's position, but anybody that has a criminal matter that keeps flip-flopping and searching for attorneys and getting rid of some and hiring some new ones, there's got to be a point where you have to say, okay, I'm going to listen to the advice that they're giving me. I mean, looking through these names of attorneys that have been on Weinstein's case, former Casey Anthony attorney Jose Baez.
If you pay my fee, I'll take your case.
Hollywood power lawyer Benjamin Brofman, Harvard law professor Ron Sullivan, ex-Kobe Bryant lawyer Pamela McKay, former prosecutor Duncan Levin. Good grief.
I know he's got a lot. Look, the first attorney that he had, or the attorney that did, for example, the preliminary hearing, was successful in getting some of the charges dismissed at the preliminary hearing. Now, that's not a small feat there, because at the preliminary, the burden of proof at a preliminary hearing, I've always viewed it as it's essentially the same burden that a law enforcement officer has to make an arrest. Arrests have to be made on probable cause. And that's essentially the same thing that a judge is looking for. They talk about it in terms of, would a reasonable person believe that based upon these facts, is there enough to entertain that the accused, that a crime has occurred and that you are the one that did it? I'm not saying you're guilty of it, but there's enough to send it to a trial. And the first attorney was successful in getting some of the charges bounced, saying, look, there's not even probable cause that something happened with that person. Yeah. So that was a win. I think that what happened in Weinstein's case, in my opinion, was influenced a little bit by what we saw happen last year with Judge Kavanaugh, when we had the accuser come in and she laid out before the confirmation board her case, and the Republicans had a female attorney come in to ask the questions because it looked different. I think after that, Weinstein wanted to get a female on board that would be more favorable to the jury, more sympathetic, able to connect, and it wouldn't look like a bunch of men against women. We're going to continue with this discussion when we come back, but we're going to talk about issues about when you get a new attorney, why, what are some of the considerations, and what are some of the things that Weinstein in particular is facing. You're listening to Radio Law Talk. We're at the bottom of the hour break. Cal?
We, in fact, are. And I want to remind you to stay tuned for more Radio Law Talk right here on this radio station. And wherever it is you're listening, we thank you. But also, just a reminder, there's always RadioLawTalk.com. Stay tuned. We'll be right back.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to RadioLawTalk.com.
Hi, my name is Lily. My mom and dad used to fight about money all the time. Then one day, I heard them talking about this guy, some uncle I never knew, called Uncle Sam. Well, they say this Uncle Sam guy wanted them to pay him like $1 gazillion, and they didn't have $1 gazillion. So they called this company they heard on the radio called the Tax Doctor. And the Tax Doctor worked with Uncle Sam's people. I think they're called the IRS. And they were able to work it out so my mom and dad didn't have to pay Uncle Sam very much money at all. So now mom and dad are happy, and I'm happy too. Thanks, Tax Doctor.
If you owe $10,000 or more to the IRS or state, call now and pay less.
800-263-2610. 800-263-2610. That's 800-263-2610.
Warning, don't let your business get left behind in what is likely to be the biggest economic boom in recent history. If you need to build for your business to grow, call General Steel today for a pre-engineered steel building designed for your needs. No wasted space. Steel prices are expected to rise, but you can still lock in your price on a General Steel building. And you can still save as much as half the cost and time of conventional construction. As much as half. But you must call now. If you need a church building, office, warehouse, manufacturing space, retail space, or more, call General Steel today. You can still get the General's 50-year structural warranty and General Steel quality, all at a price you can afford. So don't let rising steel prices put your project out of reach and stop you from making your company great.
800-617-9312. 800-617-9312. 800-617-9312. That's 800-617-9312.
Oh, come on.
Time to get back to Radio Law Talk on RadioLawTalk.com and on your favorite radio station.
So we got the Brittany Zamora case and the Taylor Swift case. I'm not trying to say they're similar, but we're going to talk about Brittany Zamora. Brittany Zamora is a school teacher in Arizona, and this is the latest thing that hit just at the end of the week, I believe. Was it a Thursday or Friday that she was sentenced to? It was Friday, to 20 years in prison for some sex crimes. And there's a little. We need to back up and kind of go through the scenario of what exactly happened in this case.
Yeah. So Zamora is a 6th grade teacher at the school that she teaches at. And the 13-year-old was a student at the school. And this case involves 2 kids, one 13, one 11, and we'll explain how they got involved. So as alleged, if the prosecutor was giving the factual basis, I would imagine this is what they would say, that Zamora was engaged in a sexual relationship with the 13-year-old student, and that they were using the 11-year-old student as a, quote, lookout to stand guard outside because this activity was taking place on the campus of the school. Now, it came to light when the parents of the 13-year-old found his phone and observed text messages, and the text messages between the 13-year-old and the teacher were very explicit and strongly suggested that a sexual relationship was going on. It was turned over, law enforcement investigated, and that's how law enforcement found out about the 11-year-old being the one that stood lookout. Interviews revealed that he did see some activity. They checked the 11-year-old's phone, and they find that at one point in time, Zamora had asked the 11-year-old a personal question about his private parts, and he didn't know what she was talking about, so she sent him a picture of a male that had those characteristics, and he responded. And the long and short of all of that is that she ended up facing charges, originally charged with 10 counts of sexual misconduct. Bear in mind that every time intercourse happens is a separate charge. So she was originally charged with 10 counts, and I believe that they were counts of actual conduct with the 13-year-old, and then there was a charge of communication with the intent to commit those acts with the 13-year-old, and communication with the intent to commit those acts with the 11-year-old based upon the context of the messages that were sent. So that's what she was charged with. That's sort of the background. She was arrested and faced the charges.
And she actually pled to it looks like it's 2 charges because one kind of looks like it's 2 parts, but she pled to sexual conduct with a minor, attempted molestation of a minor, and public sexual indecency. And that's the charge where the 11-year-old comes in, because that 11-year-old saw something that he should not have seen.
Well, she's probably got 2 charges as it relates to the 11. So we know that the sexual conduct with the minor applies to the 13-year-old.
Correct.
The other one that she pled to, which was communication.
Attempted molestation.
Attempted molestation. That would be as it relates to the 11-year-old. What they're saying is she was trying to groom him. The calls, the
exactly.
text messages and all that. And then the fact that it happened on a public campus and in
her car.
And in her car, which was to be a public place, in any place where it's reasonably likely that somebody could have seen, and the fact that they've got evidence that the 11-year-old did see, so she's good for those 3 charges. Now, she faced up to 30 years. That's what she was looking at. She entered a plea deal where the mandatory minimum was 20. Now, I don't know if the terms of the plea deal were one that they said, look, we're going to leave it up to the judge. Sometimes this happens in cases where they say, here's what we're going to do. By virtue of the plea deal, we're not going to say you can't get probation. We're going to say we'll leave it up to the judge to determine whether you get probation or whether you go to jail. And if you go to jail, you're looking at 20. If you go to prison, you're looking at 20 years. And the only reason I say that is because at the sentencing, Zamora made comments about how I just want to go home to my husband. This is not who I am. Colossal error in judgment, all of those things. And I don't see somebody making those kind of arguments about wanting to go home to your husband if it's already set in stone that you're actually going to prison. Could be wrong, but that just doesn't seem to contextually work. But the fact is she was sentenced to 20 years.
The interesting thing, too, is the court did look at mitigating factors. They looked at her lack of criminal history and the fact that screenings indicated she was not likely to reoffend, and she did appear to be remorseful in the end. However, they looked at some factors that aggravated the situation, such as her violating and abusing her position of trust over these children, and that fact she tried to conceal the crimes. And in the beginning, her defense team tried to blame the 13-year-old victim, which I think backfired badly. So anyway, the judge does look at those things too in imposing the sentence.
So here's the whole question for us at Radio Law Talk that we have brought up on this thing. Is 20 years too extreme in this case or not? Or is it not extreme enough that they should have given her more? Now, again, this is clearly a person, we're all going to agree, that has at least known prior criminal issues, pretty clean, married, just the typical all-American girl. It sounds like, a teacher, someone that we look up to in the community. And was this just a horrible mistake? But what's interesting for those of you listening to note is every state's different in the laws. And you notice the judge gave her the minimum amount. Now, other states are different, and we've talked about this. And Todd sent us an interesting article about a California sex crime detective that admits to assaulting a 15-year-old girl, and he gets a few years? Is that right?
He got 3 years of prison, and this is a guy who, for 20 years, investigated sexual assault crimes. And in this case was the investigator on a case where the victim was a victim of sexual assault, and then 15-year-old victim of sexual assault, and he engages in the same activity with her. And
what sentence did he get?
He got 3 years. And you can see contextually how the scenario would lend itself maybe to that. Here you got a victim of sexual assault. They're very vulnerable. A female victim, very vulnerable, and this guy comes in and, for all intents and purposes, might even look like the hero, going to investigate this, going to champion this, works with the victim, meets with her, they build that relationship of trust, and that has to occur. Victims, they're not just going to tell what happened to them to anybody. You got to trust the investigator, right? And with all of that happening, to have the investigator then take advantage of that, it's just wrong. But in California, based upon the sentence structure, he gets 3 years. In Arizona, the teacher, who I suppose it's similar in the sense that it's an absolute abuse of the trust and the relationship between two, she gets 20.
Yeah, I ran this by a number of people, by the way. I laid the facts out. And the three of us here, just so you know, those of you listening, agree that something's wrong with Brittany Zamora, and what she did was horrible, okay? The issue is, under the 8th Amendment, cruel and unusual punishment, right?
Yes.
Is 20 years too excessive? And without fail, the individuals that I went through this case and talked to them, they all said the same thing. She should be. They were upset at her, mad, and
she needed to do time.
And the minute I said 20 years, all of them gasped. How much?
That does seem
like
excessive.
They were shocked that much.
And I think that speaks a little bit to the amount of media coverage that it gets. And I'll give you this example. Here we are we broadcast this from Northern California. And so the folks that you asked arguably were from this locale. None of us are in Arizona. I hopped on and checked what the Arizona newspapers were reporting. And some of them, one in particular I saw, says Brittany Zamora snookers the judge into getting the minimum sentence. That people there thought she should have gotten more. And, you look at this, and intelligent minds can differ as it relates to this.
Reasonable person differ in each state, right?
Exactly. But we look at this and say 20 years, wow. I mean, if that is an appropriate sentence for her, then the cop with the sexual assault victim should be looking at the same or more, in my opinion.
20 years is an awful lot.
Hey, call us at 855-LAW-RADIO. That's 855-529-7234. Or tweet us at Radio Law Talk.
Yeah, we're going to be back and talk a little bit about this Taylor Swift recordings case. Actually, it's not a case yet. The issue is whether or not a case is going to come forward about her recordings that this individual bought for $300 million, which is quite a bit of money. And whether or not Taylor had the opportunity to buy her I guess they call them her original catalog back. But we'll be back. We'll discuss that with Todd, myself, Fred Penny, and Denise Dirks.
This is Radio Law Talk, and we thank you for listening. We'll be right back.
All advertising for legal services on Radio Law Talk is strictly for the state or states in which the advertiser is licensed. For more information, go to radiolawtalk.com.
If you're one of those independent people who wants your own business and you love food service, we just might have a great opportunity for you. Iceberg Drive-Ins. Iceberg is famous for its thick shakes and delicious food. We lend you our supply chain and expertise, and you can potentially have a thriving, successful, fun business that your customers will love. Iceberg Drive-Ins has some prime areas available right now, so if you're interested, get in touch with us right away. Go to icebergdrivein.com and click on the Contact Us button. Iceberg Drive-In, ready to grow with you.
The cost of getting rid of garbage is high, and recycling products is lucrative. If you're a business or know of a business that needs an individual compactor or baler, call Northwest Compacting at 888-201-0911. If you already have an industrial compactor, baler, or shredder and need service, don't forget to call Northwest Compacting at 888-201-0911. Northwest Compacting, your full-service industrial compacting and baling company. Read more about them at northwestcompacting.com.
Many women have so many clothes in the closet, but then we go to get dressed and find we have nothing to wear. We've all been there. We all want to be comfortable and fashionable at the same time, and it's difficult to find clothing that makes that task effortless. But at Letty & Company, you can find trendy, comfortable clothing that is affordable, things you'll want to wear every day. Shop with a purpose, online with free shipping. Just go to LETTYandcompany.com, LettyandCompany.com.
I am Cameron Levitt, Chief Operating Officer of Concussion Medical Clinic. California's first concussion medical clinic is now open. As concussions increase each year, there has never been a greater need for concussion specialists. Our physicians at Concussion Medical Clinic are board certified in pediatric neurology and sports medicine and have partnered with universities, hospitals, and rehab clinics to expedite the recovery process. Simply put, we are elevating the standard of care. When you need an expert concussion opinion or concussion care, visit concussionmedicalclinic.com to schedule your appointment.
Chris, can you put the video game controller down for a second?
I can talk and play. Oh, I'm totally annihilating this punk kid in Nebraska.
I just feel like you're not acting like a grown-up in our relationship.
Am too.
Well, you know, you still ride your skateboard to work, there's the comic book collection, the race car bed.
Look, I'm young at heart, but I put money into my 401k every paycheck. I picked up a few savings tips at feedthepig.org. I have control over my financial life now, and that feels pretty grown up.
Put away a few bucks, feel like $1 million. Putting some money from every paycheck into a savings account or contributing to your 401k can make a big difference later. For free ideas and easy tips on ways to save, go to feedthepig.org. That's feedthepig.org.
So, I bet I look like a grown-up to you now.
Well, except for the footy pajamas, I'd have to agree.
Even in the hustle and noise of this modern world, we feel the pull of the forest, to walk under the canopy and feel transformed. National forests are essential to life. Majestic and grand, they clean our air, supply drinking water to millions, and provide homes to countless wildlife. They fuel our imaginations, inspiring us to think big, and now's the time to do just that. Fires and natural disasters devastate our forests each year. That's why we're replanting millions of new trees across the country. The Arbor Day Foundation needs your help. We've heard the call of the wild and we've answered. Scientists, foresters, volunteers, and members, together we can preserve and protect our heritage and legacy. We must act now so that the generations of today and tomorrow can continue to depend on our forests. Visit arborday.org. See how you can help.
All around the world. This is RadioLawTalk.com. Radio Law Talk.
Yeah, we moved on from Brittany Zamora, but we have to back up because Todd was bringing up a good point about the judge that was recalled. There was a worry to some degree about judges who are actually giving out sentences according to what the legislator has set the law and this judge in the case of the swimmer?
The Stanford
swimmer got recalled because he basically followed what the law required him. Not required, but within the means of the law that was set by the legislators.
Allowed him.
So you remember in the analysis that I just gave about Brittany Zamora, I said that it seemed, I wasn't sure, but it seemed like they may have given it over to the judge to say, look, you can either give probation or prison, and if you go to prison, it's 20 years, right? Well, because that's what the law arguably would have allowed. In the Aaron Persky situation, Aaron Persky being the judge who oversaw the Stanford swimmer, sentencing was given to him. He exercised his discretion. Right or wrong, he exercised it within the purview of what the law allowed. And in that case, he granted probation with 6 months in jail. The guy got out in 3 based upon sentencing credits. And the public was in an uproar and ultimately recalled him. My concern was that was going to create this wave throughout the judiciary where judges looking at that going, well, if I don't want to be recalled, nobody's going to recall me for being too harsh on a sentence. So I'm going to err on the side of being very harsh. And that was my first fear with Zamora. Well, the problem with that analysis is 20 years was the minimum that she could get if she went to prison. So there's nothing really wrong with that. How do you remedy that? Is the remedy to recall? I disagree. I think the remedy, if you don't like the sentences, is to go to your legislature and get the law changed. If you don't want Persky to have the ability to give 6 months, go to the legislature and change the mandatory minimum for the offense of engaging in sexual activity with an unconscious person.
Yeah, but like you said, you were reading the newspaper articles, and there was a number of people of saying she should have got 30 years.
She should have gotten more. They thought that the judge in Arizona was as
too lenient,
snookered.
Right.
Yeah. I think people think judges abuse their discretion sometimes when they say, look, the law says 20 years, send her upriver for 20 years. This was an 11-year-old kid, and she's sending, I mean, come on, right? I mean, I think, I'm just telling you that many times the irritation comes when the law says this, and then the judge says, well, traditionally, so I'm going to exercise my discretion. And the law isn't really followed, but that's okay for the judge and the courts. It's not okay for the people on the outside of the system.
Well,
and that's what people are
I'm going to argue yes or no. Go ahead.
Yeah, I was going to say, we have to be so careful because judiciary does not create the law. It's a legislative branch that creates the law, except in the case of stare decisis, which means case law does come up.
Right.
But in this criminal justice system, the legislature in California has set the standards maybe a little bit lower than what public is right now. And if, in fact, we believe that the sentencing guidelines should be stronger, we need to address that with our legislature.
That's right.
But I think getting to Cal's point, if I understood Cal's point correctly, it is that it's not an issue for us about whether the judge can or can't. I think we all understand they can't. It's that the general public, with the general public's average understanding of the judiciary, we can see a judge that sentences somebody within the purview of what the judge can sentence. And I don't think that the public necessarily gets that they're sentencing. In the case of Aaron Persky, I don't think that the public necessarily got that he was sentencing within the purview of what the law allowed. They just viewed it as, this is judicial abuse of discretion, that he shouldn't have done that, not realizing that he didn't deviate from what happened. It's not like the judge went, I know that the law requires me to put you in prison for 3 years, but I'm going to go rogue and do whatever I want to do and give you 6 months. He did what he did. If you don't like it, change what the judge can do.
And that's what I'm trying to say, too, with the judges also. Nowadays, with the social media and everything happening so fast, everyone is a judge out there off a 2-second review of Twitter. And that's what irritates me a little bit is these judges, and again, they're not perfect. Don't get me wrong, they're going to make mistakes, but they're looking at all the evidence, all the details. The famous McDonald's case everybody knows about. Oh, my gosh, because don't forget, us as lawyers, I've read and studied it. Oh, that was that's crazy. The
McDonald's meeting where the woman spilled coffee on her lap.
Coffee down her lap. Right. And that was, but they didn't know the judge did what's called a remitter. A remitter means he reduced the case because he thought it was too much and didn't know about the facts of who was testifying to what? But the judge is right there. The judge is studying it. The judge hears everything and all the evidence the whole time, and all you hear out there is what the media tells you. So we have to give some discretions to our judges.
Yes, and Judge Persky was actually cleared of any abuse of discretion by the Judicial Commission. So.
And that didn't matter to the public.
Yeah.
You see, that's the point.
Yeah.
To the public, it comes off as an academic exercise, not an exercise in justice.
Right.
And that's the issue here. I understand what you're saying. He did everything in quotes legally, did everything in quotes. But you know what? At the end of the day, there was an unconscious girl raped by a guy, and he served 3 months in prison.
Right.
Now, to the general public, what are you going to say? Oh, well, it was within the purview. No, you're not going to say that.
No, you're not. You're going to say that the judge did it wrong. But when you look at who's really in charge of sentencing guidelines, it's not the judge.
Yeah, and if you know, look, if you go to our podcast, look up last week's show, we talked about the judges in New Jersey that on a case where whether a teen should be tried as an adult or as a teen, was a 16-year-old kid that sexually assaulted an unconscious person and took video of it, right? Takes video of it, and on the video says, when your first time having sex is being raped. I mean, terrible. And the judge has the audacity to question whether or not the victim was really intoxicated, that the prosecution should have had a discussion with that victim about her ruining the life of this 16-year-old because he came from a good family and looked like he had good prospects going to college. Yeah. And mind you, on appeal, he was thoroughly reamed by the.
That's the difference.
He needs to be reamed.
But the problem is, from the public's perspective, they see a judge like that, and then they see a judge like Aaron Persky. They're all lumped into the same category.
Yeah. Right. And Persky was again. I'm not disagreeing with you, Cal, that this was a small amount, but he worked within the system that was given to him by the legislator, and there are checks and balances for judges, and Denise brought it up. There is a judicial committee. They can be disciplined by them, and they reviewed it and found he did nothing wrong.
I am waiting for the legal treatise, the legal book to come out that says how to effectively litigate your case into 140 characters or less, because that's what we need. And we got the Twitters, Facebook, and the whole case is litigated in what you can put in a tweet, what you can say in a 30-second soundbite. That's what it boils down to.
And also, you have to understand the political climate right now, which is to reduce sentencing, hold people less accountable. I mean, in California, there's an rumbling undertone that criminals are being held much less accountable for their maldeeds. Those that were felons, now they're misdemeanors. The misdemeanors are being out flooding the streets and committing more crime. I mean, it's a simple fact. So people are upset about that. Yes. And then they see this happen, and there's this rumble underneath. See, I told you nobody's being held accountable. And you say, go to the legislature, and the legislature says, we're not going to build any more jails.
That's the issue. And I'm going to say that. But we're not political. Go ahead.
I think we're forgetting one really important part. California is in the minority when it allows for removal of judges by recall. Most of the states do not. So most of the rumblings that come around, the public does feel a little less able to impact that judge or to have any influence on the judge because he can only be removed for a criminal act.
And to me, that's the ultimate irony. I think that Cal's talking about is if you poll people nationwide, they're going to say that California is the one that looks like they are leaning more towards reduced sentences for criminals and all of that. Yet California is one of the only states that allows recall of judges, and the one that happened most recently is because a judge went too light on a defendant. I mean, that's sort of ironic.
It comes down to whether or not do you leave more discretion to the judges or not, and how much are we being taught by Twitter, Instagram, Facebook, and all that stuff. So, hey, we tried the best we could to get to the Taylor Swift case and the Scooter Braun. We want to talk about it, but remember, you can go on to radiolawtalk.com, go to the Listen Live, and you can hear us live talk about it. We just have so much fun here, and we have so many interesting topics to talk about. We just can't get to all of them. I wish we could. Call us at 855-LAW-RADIO or tweet us at Radio Law Talk. And if you have some topics you want to talk about during the week, info@radiolawtalk.com. We will see you in another hour.
This is Radio Law Talk.
have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated.
Scenario, but it happens. Dennis writes about his wife. She was diagnosed with leukemia. In fact, she's a 2-time survivor, and in the midst of all that, they ran up over $1 million in medical bills. Thankfully, they're Medi-Share members, and Dennis says they are so thankful for that, how others came together to meet their needs, and that's how so many Medi-Share members feel. This is not health insurance. It's different. You don't have to pay for things you don't believe in. And like Dennis found out, it just works. So if you join Medi-Share, not only do you save a lot of money, the typical family saves about $500 a month, but you know where your money's going each month. You're helping people, and if the time should come, they'll be helping and even praying for you. So yes, it's different, and as more than 400,000 people now know when it comes to healthcare costs, different is beautiful. Find out more. Call 833-34-BIBLE. That's 833-34-BIBLE. 833-34-BIBLE.